Chapter 1. Introduction to Ethiopian Criminal Law. Welcome to this comprehensive exploration of Ethiopian criminal law. Today, we begin by delving into the roots, structure, and purpose of the legal framework that governs criminal behavior in Ethiopia. Part 1. Overview of criminal law. Criminal law is a foundational element of any legal system. It is designed to regulate behavior, define crimes, and prescribe punishments. In Ethiopia, criminal law represents a set of rules aimed at protecting society from harmful actions and ensuring justice is served. According to the Criminal Code of the Federal Democratic Republic of Ethiopia 2005, the primary objectives of criminal law are to protect individuals and property, to deter criminal actions, to punish wrongdoing, and to rehabilitate offenders. Criminal law is unique. It goes beyond civil wrongs and moral breaches. It directly impacts societal order by holding individuals accountable to the state. Part 2. Historical development of Ethiopian criminal law. Ethiopia has a rich legal history dating back to the Fuse Menfesawi in the 15th century. This early legal code was the first known attempt to formalize criminal laws, largely influenced by religious principles. However, the most significant early codification came in the form of the Fetha Negist, or Law of Kings, a legal document that shaped Ethiopia's legal tradition for centuries. It included principles that still influence Ethiopian law today, such as those concerning intention, negligence, and punishment. In the modern era, Ethiopia created its penal code in 1930, followed by the Penal Code of 1957, which further defined criminal conduct and set the stage for contemporary reforms. But the most pivotal change came in 2005 with the enactment of the Criminal Code of the Federal Democratic Republic of Ethiopia. This comprehensive code aligned Ethiopia's legal framework with international standards and addressed new challenges posed by modern society. Part 3. Objectives of criminal law in Ethiopia. Criminal law in Ethiopia serves several core objectives as outlined in the 2005 Criminal Code. Let's break these down. Protection of persons and property. The foremost objective is to protect the life, liberty, and property of individuals. Criminal law ensures that citizens feel safe and secure, knowing that those who harm others or infringe upon property rights will be held accountable. Deterrence of criminal behavior. Criminal law also acts as a deterrent. The threat of punishment, whether through fines, imprisonment, or other penalties, discourages individuals from engaging in criminal acts. This preventive function is key to maintaining order in society. Punishment of criminal activity. When crimes are committed, the law steps in to punish the wrongdoer. Punishments range from fines to life imprisonment and, in some cases, the death penalty. This approach aims to correct the offender's behavior and provide a sense of justice for both victims and society. Rehabilitation of criminals. Ethiopia's criminal justice system seeks not only to punish but also to rehabilitate. Programs within the prison system aim to reform offenders, equipping them with skills and education to reintegrate into society as productive citizens after serving their sentences. Conclusion of Chapter 1. Setting the stage for deeper exploration. With these key elements in mind, we've set a foundation for a more detailed look into Ethiopian criminal law. In the next chapter, we will explore the core principles that underpin criminal law in Ethiopia, principles that govern legality, equality before the law, and individual autonomy. Stay tuned as we dive deeper into the framework that upholds justice in Ethiopia. Chapter 2. The Principles of Ethiopian Criminal Law. These principles ensure that justice is applied fairly and consistently, and that everyone is equal under the law. Part 1. The Principle of Legality. One of the cornerstones of Ethiopian criminal law is the principle of legality. This principle, expressed by the Latin maxim nullum crimen sine lege, means that no one can be prosecuted for an act unless it has been explicitly defined as a crime by law. In essence, you cannot be punished for something that wasn't illegal at the time it was committed. This principle is enshrined in the Criminal Code of 2005, ensuring that laws are clear and public so citizens know exactly what behavior is punishable. It prevents the state from arbitrarily punishing actions that aren't codified as crimes. Let's consider an example. If someone is accused of committing a crime today, we must ask whether their action was defined as a crime under Ethiopian law at the time of the act. If not, the principle of legality protects them from punishment. Another related concept is nulla pona sine lege, which means that no penalty can be imposed without a prior law prescribing it. In this way, punishment is always linked to the legal framework in place when the crime was committed. Part 2. The principle of equality. The principle of equality under Ethiopian law means that all individuals are treated equally before the law, regardless of their status, ethnicity, or background. Article 25 of the Constitution of Ethiopia guarantees equality, which is mirrored in the Criminal Code. However, there are exceptions, particularly concerning certain immunities. For example, diplomatic personnel and government officials may be shielded from prosecution under international or domestic law. Furthermore, Ethiopian law makes provisions for special treatment of specific groups such as women, minors, and the mentally ill. This ensures that while everyone is equal under the law, those who require special protection or consideration receive it. Part 3. The principle of individual autonomy. Another key principle is individual autonomy. This principle asserts that individuals are responsible for their own actions. In criminal law, this means that a person can only be held liable for crimes that they have committed of their own free will with full knowledge and intent. In practice, this principle is important when determining mens rea or criminal intent. For example, if someone commits a crime under duress or coercion, their autonomy is compromised and their liability may be reduced. Would you like me to proceed with Chapter 3, Crime and Criminal Liability in Ethiopia, and further develop the subsequent chapters? Chapter 3, Crime and Criminal Liability in Ethiopia. In this chapter, we will examine the concept of crime in Ethiopian law and explore the conditions under which someone can be held criminally liable. Understanding the core elements of what constitutes a crime and how criminal liability is determined is essential for law students and legal practitioners. Part 1. What constitutes a crime under Ethiopian law? At its core, a crime in Ethiopian law is defined as an act or omission that violates the law and is punishable by the state. The Criminal Code of 2005 provides a detailed explanation of what constitutes a crime. Crimes can range from offenses against the state, such as treason, to offenses against individuals, such as murder, theft, or assault. However, not every wrong or harmful act is considered a crime. For example, civil wrongs or torts like breach of contract are not treated as crimes but instead fall under civil law. According to the Criminal Code, a crime generally includes the following components: commission of a prohibited act, omission of a required act, and intent or negligence. Case example: consider a scenario where someone deliberately destroys another person's property. The act of destruction itself is a prohibited act under the Criminal Code, making it a crime. Similarly, if a person fails to perform a duty that results in harm such as a parent neglecting their child, this omission can also constitute a crime. Part 2. The essential elements of crime. To hold someone criminally liable, 3 key elements must generally be present. Legal element: act must be defined by law as a crime. Material element: the physical action or omission. Moral element: intent or state of mind. Legal element: the legal element means that an act must be prohibited by law. Under the Criminal Code of Ethiopia, crimes are clearly defined, and only those acts listed in the code are subject to criminal penalties. For instance, theft is explicitly prohibited under the Criminal Code. If someone unlawfully takes another person's property, they are committing an act defined as illegal, fulfilling the legal element of a crime. Material element: the material element, or actus reus, refers to the physical act or omission that constitutes the crime. This could be an act of violence, like hitting someone, or an omission, such as failing to report a crime when there is a legal obligation to do so. For example, if a driver hits a pedestrian while speeding, the material element of the crime is the act of hitting the pedestrian. If the driver fails to stop and provide help, their omission can also be considered part of the crime. Moral element mens rea. The moral element, or mens rea, is one of the most important factors in determining criminal liability. It refers to the intent or state of mind of the offender. For a crime to occur, the individual must generally have intended to commit the act or, at minimum, acted with gross negligence. There are two primary types of mens rea. Direct intention, when someone deliberately commits a crime, such as planning and carrying out a robbery. Negligence, when someone's failure to act responsibly results in harm, even if they did not intend to cause harm. For example, a doctor who negligently causes the death of a patient may be criminally liable for that death. Material element. The material element, or actus reus, refers to the physical act or omission that constitutes the crime. This could be an act of violence, like hitting someone, or an omission, such as failing to report a crime when there is a legal obligation to do so. For example, if a driver hits a pedestrian while speeding, the material element of the crime is the act of hitting the pedestrian. If the driver fails to stop and provide help, their omission can also be considered part of the crime. Moral element mens rea. The moral element, or mens rea, is one of the most important factors in determining criminal liability. It refers to the intent or state of mind of the offender. For a crime to occur, the individual must generally have intended to commit the act or, at minimum, acted with gross negligence. There are two primary types of mens rea. Direct intention, when someone deliberately commits a crime, such as planning and carrying out a robbery. Negligence, when someone's failure to act responsibly results in harm, even if they did not intend to cause harm. For example, a doctor who negligently causes the death of a patient may be criminally liable for that death. Part 3. Conditions of criminal liability. Criminal liability arises when an individual meets the conditions of a crime under Ethiopian law. These conditions include intent, negligence, and sometimes strict liability for certain offenses. Intention mens rea. Intent is central to most crimes. The law requires that the perpetrator acted with knowledge and purpose. A person cannot generally be held liable for a crime if they acted involuntarily or were unaware of the consequences. For example, if someone knowingly breaks into another person's house to steal, they are acting with criminal intent. Their actions were deliberate, and they understood that what they were doing was illegal. Negligence. In some cases, a person can be held criminally liable even if they did not intend to commit a crime. Negligence occurs when someone fails to take reasonable care and their carelessness causes harm to another person. For instance, a driver who accidentally hits a pedestrian while speeding may not have intended to cause harm, but their negligent behavior makes them criminally liable. Strict liability. There are also certain crimes where intent or negligence does not need to be proven. These are known as strict liability offenses. In such cases, the mere commission of the prohibited act is enough to establish liability, regardless of the offender's mental state. An example would be selling alcohol to minors. Even if the seller did not know the beer was underage, they can still be held criminally liable under strict liability laws. Part 4. Corporate criminal liability. Ethiopian law also recognizes corporate criminal liability, meaning that legal entities, such as companies, can be held responsible for criminal activities. This is particularly relevant in cases of fraud, environmental violations, or human rights abuses committed by corporations. Goals of corporate liability. The aim of corporate liability is to ensure that companies and their leaders are held accountable for wrongdoing. Under Ethiopian law, both the company as a legal entity and its officers can face penalties for illegal actions. Types of corporate criminal liability. Corporate liability may take several forms. Criminal liability. If the company is directly involved in illegal activities. Vicarious liability. When the actions of employees or agents result in harm, the company can be held responsible. Case example. In a case where a factory causes environmental damage by illegally dumping waste, both the company and its managers could face criminal charges under Ethiopian law. Conclusion of Chapter 3. Understanding liability in Ethiopian law. Understanding the elements of a crime and the conditions of criminal liability is fundamental to grasping Ethiopian criminal law. Whether the crime is committed with intent, negligence, or involves corporate entities, liability must be carefully examined in each case. Chapter 4. Jurisdiction and application of Ethiopian criminal law. In this chapter, we will focus on the concept of jurisdiction in Ethiopian criminal law. Jurisdiction determines the scope and authority under which the criminal code can be applied, defining where, when, and to whom the law applies. Understanding jurisdiction is essential for both law students and legal practitioners to know the limits of criminal law enforcement in Ethiopia. Part 1. Territorial jurisdiction. Territorial jurisdiction refers to the geographic area where the criminal law of Ethiopia applies. The Criminal Code of the Federal Democratic Republic of Ethiopia 2005 states that criminal law primarily applies to offenses committed within the national territory. This principle is rooted in the concept of sovereignty, where each country has the right to enforce its laws within its borders. Principal jurisdiction. The principal jurisdiction of Ethiopian criminal law applies to all crimes committed within the territorial boundaries of Ethiopia. This includes land, airspace, and territorial waters. It also covers crimes committed on Ethiopian ships and aircraft, regardless of where they are located, as long as they are registered in Ethiopia. For example, if a crime such as theft or homicide occurs within Ethiopian territory, it falls under Ethiopian law, and the offender will be prosecuted according to the country's criminal code. Extraterritorial application. While the focus of Ethiopian criminal law is on crimes committed within the country, there are situations where the law applies to offenses committed outside its borders. This is known as extraterritorial jurisdiction. Ethiopia may claim jurisdiction over offenses committed by Ethiopian citizens or against Ethiopian citizens abroad, particularly in cases where the crime involves significant national interests or public safety. For instance, if an Ethiopian national commits a serious crime abroad, such as human trafficking, and later returns to Ethiopia, they may be prosecuted under Ethiopian law, even though the crime occurred in another country. Additionally, Ethiopian law applies to certain international crimes, such as terrorism, war crimes, and crimes against humanity, regardless of where they are committed. This extraterritorial reach is part of Ethiopia's commitment to international law and cooperation in fighting global crimes. Part 2. Subsidiary jurisdiction. Subsidiary jurisdiction comes into play when another country's legal system cannot or does not prosecute a crime that falls under Ethiopian criminal law. In such cases, Ethiopian courts may claim jurisdiction, especially if the crime affects Ethiopia or its citizens directly. Example: if an Ethiopian national is involved in a cybercrime that affects the country's national security but the crime was carried out abroad, Ethiopian authorities may invoke subsidiary jurisdiction to prosecute the individual. Part 3. Extradition laws under Ethiopian criminal law. Another critical aspect of jurisdiction is the concept of extradition, which allows countries to transfer individuals accused or convicted of crimes to other nations for prosecution or punishment. Under Ethiopian law, extradition is an important tool for international cooperation in criminal justice. Extraditable persons. According to the Criminal Code of Ethiopia, both Ethiopians and foreign nationals can be extradited under specific conditions, provided that there is a formal extradition treaty between Ethiopia and the requesting country. However, Ethiopian law prohibits the extradition of its own citizens in certain situations. For example, if an Ethiopian citizen is accused of a political crime in a foreign country that does not align with Ethiopian law, extradition may be denied to protect the individual's constitutional rights. Extraditable crimes, extradition is generally limited to serious offenses such as murder, terrorism, or drug trafficking. Minor offenses are not typically grounds for extradition unless the crime has significant international implications. The extradition process in Ethiopia follows a formal procedure outlined in the Criminal Code. Requests for extradition must come through official diplomatic channels, and the case is reviewed by Ethiopian courts to ensure compliance with both domestic and international law. Once a court determines that the conditions for extradition are met, the individual is handed over to the requesting country for prosecution. If extradition is denied, Ethiopia may assume jurisdiction and try the accused under its own laws, depending on the circumstances of the case. Part 4. Place and time of crime. To determine whether Ethiopian criminal law applies, it is crucial to establish the place and time of the crime. Crimes are usually prosecuted based on where they were committed and the law in force at that time. Place of crime. The place of crime refers to the location where the criminal act was committed. Ethiopian law requires that criminal cases be tried in the jurisdiction where the crime occurred, whether in urban or rural areas. For example, if a person is accused of burglary in Addis Ababa, the case will be tried in the Addis Ababa jurisdiction. If the crime occurs in a remote area, the local courts will have authority to handle the case, ensuring that justice is accessible across the country. Time of crime. Criminal offenses must also be examined based on the time at which they were committed. Ethiopian law does not apply retroactively, meaning that a person cannot be prosecuted for an act that was not a crime at the time it was committed. The principle of non-retroactivity is a fundamental safeguard against unfair legal proceedings. For instance, if a law is passed in 2023 banning a certain behavior, someone who engaged in that behavior in 2021 cannot be prosecuted under the new law. Conclusion of Chapter 4. Jurisdiction and the reach of Ethiopian criminal law. Understanding jurisdiction is critical for applying the law fairly and justly. Whether within Ethiopia's borders or beyond, the Criminal Code has mechanisms to ensure that offenders are held accountable while respecting international legal frameworks. In the next chapter, we will explore the degrees of crime in Ethiopian law, looking at how crimes are classified based on the seriousness of the offense and how criminal participation is handled within the legal system. Chapter 5. Degrees of crime and participation in crime. In this chapter, we will explore the different degrees of crime under Ethiopian law and examine how the Criminal Code handles the participation of individuals in crimes. Crimes are classified based on their seriousness, and the legal system recognizes varying levels of involvement, from direct perpetrators to accomplices. Understanding these distinctions is crucial for properly applying criminal liability. Part 1. Different stages in the commission of a crime. In Ethiopian criminal law, crimes are not always judged. The law recognizes 3 primary stages: preparation, attempt, and completion of a crime. Preparation involves the planning or arrangement of tools and means to commit a crime. In most cases, preparation is not punishable under Ethiopian law unless it is explicitly criminalized. The reasoning is that a person should not be punished for merely intending to commit a crime without taking direct steps to carry it out. For example, if someone purchases materials with the intent to create counterfeit currency but takes no further action, Ethiopian law does not generally punish them for the preparation phase alone, unless a specific law covers it. An attempt occurs when a person takes substantial steps toward committing a crime but does not complete the offense. In Ethiopia, an attempt is punishable, although the penalty is usually less severe than for a completed crime. Consider a case where someone tries to break into a house but is caught before stealing anything. Although the theft was not completed, the individual can still be charged with attempted burglary under Ethiopian law. Types of attempt: complete attempt, when the person carries out all steps necessary for the crime but fails to achieve the desired result, for example, shooting at someone but missing. Incomplete attempt, when the person is interrupted before completing all necessary steps, for example, being arrested while breaking into a house. Completion, the completion of a crime refers to the successful execution of the prohibited act. Once the crime is completed, full criminal liability applies, and the offender faces the maximum penalties prescribed by law. Part 2. The importance of distinguishing between preparation and attempt. The distinction between preparation and attempt is essential in Ethiopian criminal law because it determines whether or not criminal liability arises. While preparation alone may not be enough to bring charges, an attempt shows that the person has taken clear steps to commit the crime, warranting punishment. Example: if someone purchases tools to commit a robbery, this is preparation. But once they enter the targeted building with the intent to rob, it becomes an attempt. The line between the two is critical in deciding how to prosecute the individual. Part 3. Renunciation and active repentance. Renunciation occurs when a person decides not to complete a crime they were about to commit. If this renunciation is voluntary and occurs before the crime is attempted or completed, the individual may avoid criminal liability in some cases. Active repentance, on the other hand, happens when the individual takes steps to prevent the crime after beginning the attempt. For example, if someone begins a robbery but then decides to stop and leaves the scene before taking any money, this could be in some instances, the Ethiopian Criminal Code provides for mitigation or exemption from punishment in such cases. Part 4. Participation in crime. Ethiopian criminal law also recognizes different degrees of participation in crime. It is not only the individual who directly commits the crime who can be held liable, but also those who aid, abet, or encourage the crime. This section explores the roles of principal offenders, co-offenders, and those involved in a secondary capacity. Principal offenders. The principal offender is the person who directly commits the crime. Whether through their own actions or by using others to carry out their plan, the principal offender is the main individual held responsible for the offense. For example, in a homicide case, the person who directly commits the murder is considered the principal offender. Co-offenders. Co-offenders are individuals who jointly commit a crime together. Ethiopian law recognizes the concept of co-offenders when two or more people collaborate in planning and executing a criminal act. For instance, if two people conspire to rob a bank and both actively participate in the robbery, they are considered co-offenders. They share equal responsibility under the law. Moral and material criminal participation. In Ethiopian law, criminal participation is divided into moral and material roles. Material participation, when a person physically contributes to the commission of the crime. Moral participation, when a person incites, encourages, or aids in the commission of a crime without directly participating in the act. For example, a person who provides weapons for a robbery without being present during the crime is considered a moral participant, while someone who physically carries out the robbery is a material participant. Indirect criminal participation. In some cases, a person may not directly commit the crime but still be held liable as an indirect participant. This can occur when an individual manipulates or coerces another person to commit the offense. For instance, if a person forces someone to commit a crime under duress, the person issuing the orders can be held indirectly responsible. Criminal conspiracy and incitement. Ethiopian law also punishes individuals who conspire to commit a crime, even if the crime is never carried out. A criminal conspiracy occurs when two or more people agree to commit an unlawful act. Incitement involves encouraging or persuading others to commit a crime. For example, if a group of individuals plans an armed robbery but is arrested before the robbery takes place, they can still be charged with criminal conspiracy. Similarly, if someone incites others to riot, they can be held accountable even if they do not participate in the violence themselves. Part 5. Concurrence of crimes. Sometimes an individual commits multiple crimes. This situation is known as concurrence of crimes, and it refers to the commission of several offenses by the same person. Ethiopian law recognizes this and provides guidelines on how to handle such cases. Guilt in case of concurrence. When multiple crimes are committed, the courts in Ethiopia consider whether the offenses were closely related or occurred as separate actions. This distinction is essential in determining the sentence. For instance, if someone breaks into a house and commits theft and assault during the same act, these crimes are considered in concurrence. The judge may impose a combined sentence based on the severity of the offenses. Sentencing for concurrence. In cases of concurrence, Ethiopian law allows for cumulative punishment or joint sentencing. This means that the offender may face separate sentences for each crime, or the sentences may be combined into one. For example, if someone is convicted of robbery and assault, they may receive separate sentences for each crime, but the court can choose to merge them into a single sentence based on the totality of the offenses. Conclusion of Chapter 5: Degrees and Participation in Crime. Ethiopian criminal law provides clear distinctions between different stages of crime, from preparation to completion, as well as between various forms of participation. Whether as a principal offender, co-offender, or someone in a moral capacity, individuals are held accountable based on their level of involvement. The concept of concurrence of crimes ensures that justice is served when multiple offenses are committed. In our final chapter, we will discuss the future of Ethiopian criminal law and explore how recent reforms are shaping the legal landscape in the country. Chapter 6: Conclusion: The Future of Ethiopian Criminal Law. In this concluding chapter, we'll look at the current challenges, ongoing reforms, and the future direction of criminal law in Ethiopia. As Ethiopian society evolves, so too must its legal system in order to meet new challenges, uphold justice, and ensure that the criminal code remains relevant. Part 1: Challenges facing Ethiopian criminal law. While the Criminal Code of 2005 has been instrumental in modernizing Ethiopian criminal law, several challenges remain that require attention. One of the biggest challenges is the capacity of the legal system to handle an increasing number of complex crimes, such as cybercrime, human trafficking, and terrorism, technological advancements, and cybercrime. With the rapid advancement of technology, new forms of crime such as cybercrime pose significant challenges. Ethiopian law must continuously adapt to address offenses like identity theft, financial fraud, and hacking, which transcend national borders and require international cooperation. For example, the rise of internet-based criminal activities has forced the government to look into updating legal human trafficking and organized crime. Human trafficking is another major issue facing Ethiopia, particularly given its strategic position in the Horn of Africa. The Criminal Code provides penalties for traffickers, but law enforcement agencies face significant challenges in tracking and prosecuting those involved in complex, organized crime networks. Ethiopia has committed to working with international organizations to combat human trafficking, but improvements in the legal process and international collaboration are still necessary to address the full scale of the problem. Legal system backlogs and resource constraints. One of the most significant issues affecting Ethiopian criminal law is the overburdened legal system. With limited resources and a growing population, courts often face backlogs of cases, leading to delays in delivering justice. Efforts to reform the judicial process and invest in legal infrastructure are underway, but more needs to be done to ensure that criminal cases are handled in a timely and efficient manner. Part 2: Ongoing reforms in Ethiopian criminal law. Despite these challenges, there are ongoing reforms aimed at strengthening Ethiopia's criminal justice system and making it more responsive to the needs of society. These reforms focus on modernizing laws, improving law enforcement capabilities, and promoting human rights. Criminal Code amendments. The Ethiopian government has been working to amend the Criminal Code of 2005 to address new types of crime and improve clarity on issues such as corporate liability, corruption, and environmental offenses. These amendments aim to close legal loopholes and better define punishments for modern-day crimes. For instance, the law on corruption has been strengthened to ensure that public officials who misuse their power are held accountable. Similarly, environmental crimes are receiving more attention as Ethiopia works to protect its natural resources from illegal exploitation. Focus on rehabilitation and restorative justice. There is also a growing emphasis on rehabilitation and restorative justice in the Ethiopian criminal system. New programs are being implemented in prisons to provide education and skills training to inmates with the goal of reducing recidivism and helping former offenders reintegrate into society. Restorative justice practices are being encouraged where offenders are given the opportunity to take responsibility for their actions and work toward making amends to their victims and the community. This is a significant shift toward a more holistic approach to criminal justice. Part 3. The role of law students and future legal practitioners. As Ethiopian criminal law continues to evolve, the role of law students and future legal practitioners will be critical in shaping its future. By engaging with the ongoing reforms and staying informed about legal developments, the next generation of lawyers and judges can play a key role in strengthening the legal system. Staying informed and engaged, law students should continuously engage with current issues in criminal law such as emerging cyber crimes, human rights law, and the global fight against organized crime. Keeping up with legal changes and judicial rulings is essential for staying at the forefront of the legal profession. In addition to formal legal education, students should participate in legal debates, attend conferences, and engage in practical experiences such as internships with law firms or government agencies. Advocating for legal reform, law students and young practitioners also have the potential to be advocates for change. Whether through legal research, advocacy groups, or even legislative assistance, the legal community plays a vital role in pushing for reforms that make the criminal justice system more just and accessible. Conclusion: the future of Ethiopian criminal law. As we conclude our exploration of Ethiopian criminal law, it's clear that while the legal system has come a long way, it faces ongoing challenges that will require careful attention and continued reform. By addressing the complexities of modern crime, improving legal infrastructure, and embracing rehabilitation and restorative justice, Ethiopia is moving toward a more effective and humane criminal justice system. For law students and future legal professionals, the path ahead is both challenging and rewarding. You are the future guardians of justice in Ethiopia, and your work will be essential in upholding the rule of law, protecting human rights, and ensuring that justice is served for all. Thank you for joining us. We hope this exploration has provided you with valuable insights and a solid foundation for your legal studies and future career in criminal law.